You know, the world of legal ethics can be a real minefield. It's this complex web of rules where one tiny misstep, even with the best of intentions, can put a lawyer's entire career in jeopardy. Today, we're going to see that in action, all through the story of one attorney and one single decision. So picture this. It all starts out as a feel-good story. You've got an attorney fighting for the little guy, a man named Peter who's been made sick, he believes, by a chemical company. And with the help of Peter's doctor, they go up against this corporate giant, and they actually win. But here's the twist. This story isn't really about the win. It's about what happens after the confetti settles. A simple gesture, an act of gratitude, ends up creating this massive ethical problem that threatens to just undo everything. So what was that critical mistake? That's the big question we're going to unpack together. We're going to go back and trace every single step this attorney took to find that precise moment where everything went sideways. Okay, so here's the journey. We've got 4 key moments. First, how he reached out to doctors. Second, hiring the doctor as an expert witness. Third, her testimony in court. And finally, the gift. We're going to put each one under the microscope and see exactly where the crack in the foundation appeared. All right, let's start at the very beginning. The attorney mailed out a professional announcement to local physicians. Is that just smart marketing, or is it already dipping a toe over the ethical line? Well, when you look at the rules on advertising, whether it's the national ABA rules or the specific ones in California, they all kind of boil down to one main idea. Just be honest. You can't be misleading, you definitely can't promise a win, and you have to say who you are. It's all about protecting the public. And yup, our attorney totally nailed this one. He played it straight by the book. His announcement was just the facts, no fluff, no false promises, just his name, address, and what he does. So step 1 is a clean pass. He's in the clear. Okay, so far so good. But now we move on to step 2. The doctor who sent Peter his way is now going to be an expert witness. The attorney agrees to pay her for her time. Is that okay? Or does it start to look like he's just buying the testimony he wants? Now, this is really interesting because the rules draw a super bright line here. You can absolutely pay an expert for their time and their knowledge. I mean, that's only fair. But, and this is a huge but, you can never make that payment contingent on winning. Because if you did, you'd basically be giving them a reason to say whatever it takes to win, right? You'd be paying for a result, not for their honest expertise. And that's exactly what our attorney did. He set up a standard, reasonable fee of $200 an hour. She'd get paid that whether they won the case, lost the case, or it's settled. It had nothing to do with the outcome. So, check another box. The attorney is 2 for 2. He followed the rules for paying an expert witness to the letter. No ethical problems here. Moving on. Okay, but this is where things start to get murky. The attorney finds out there are other scientific studies out there that seem to contradict what his own expert is saying. So is it unethical for him to put her on the stand anyway? So there's this big rule called candor to the tribunal, which sounds really fancy, but it all comes down to one single powerful word, knowingly. An attorney only breaks this rule if they present evidence they know is false. Just having a doubt or knowing there's a debate about it isn't the same thing as knowing it's alive. And this is the key to the whole thing. The attorney was aware of the other studies, sure, but he didn't know for a fact that the doctor's conclusions from her own clinical experience were wrong. He was in a state of uncertainty, which is very different from knowing something is false. So believe it or not, the verdict is no violation. The whole point of a trial is to weigh competing evidence. As long as the attorney isn't intentionally pushing a lie, he's allowed to present his side. He's still clean. 3 for 3. All right, the trial's over. They won, everyone's happy, and then the attorney sends a thank you gift, a $500 gift certificate to the doctor. And this right here is the moment everything unravels. And oh man, it's not even just the gift. It's the note he attached to it. He literally spelled it out. The gift was to thank her for recommending Peter to him. He created his own paper trail, his own evidence against himself. So here we are. After navigating all these other tricky situations perfectly, was this one simple thank you the fatal mistake? And the answer is a huge, flashing yes. There's a hardcore rule against what are called improper referral fees. Basically, you can't pay for clients, period. You can't give someone something valuable in exchange for sending business your way. It's a classic quid pro quo, this for that, and it is a fundamental no-no. And boom, that's it, a textbook violation. The gift, combined with that specific note, turned a thank you into a payment for referral. It doesn't even matter if his heart was in the right place. The act itself is the problem. But wait, it gets even worse. You gotta step back and think about the optics here. He just gave $500 to a key witness right after her testimony helped him win a case. Even if the note says it's for the referral, what does that look like? It looks like he's rewarding her for her testimony, and that appearance alone is poison to the integrity of the whole system. So let's just look at the final scorecard. The advertising? Perfect. Paying the witness? Done by the book. Putting her on the stand? Totally defensible. He was almost at the finish line, completely in the clear. And then, a $500 gift and one poorly written note brought the whole thing crashing down. Which leaves us with one heck of a question to chew on, right? What if he'd sent the exact same gift, but didn't write the note? Would that still have been a violation? It just shows you how in the world of legal ethics, sometimes what things look like is just as damaging as what they actually are. So, what do you think?